afternoon. I'm Kurt Levy, president of the Committee for Justice, which is hosting this panel about the recent decision in US v. Google. That case is at the forefront of the debate over whether big tech has become too powerful. It's the biggest tech antitrust case since the US sued Microsoft more than 20 years ago. And then a federal judge last month ruled that Google violated the antitrust laws by using anti-competitive practices to maintain a monopoly in markets for general internet search and search-based advertising. The judge pointed to Google's exclusive distribution agreements, in which Google is set as the default search engine on various browsers and devices. And our panel of experts will weigh into that debate. Now, this case is not to be confused with other US v. Google, with the other US v. Google case, which accuses Google of monopolizing the market in ad tech, that is, internet ad technology. And that case is ongoing in the Eastern District of Virginia. There's not been a decision yet. Other details I will leave to our experts, Alden Abbott, Asheesh Agarwal, and Bilal Sayyed. They'll explain the court's decision, potential remedies the judge might impose, the decision's ramifications for big tech, for consumers, for antitrust law. And after they speak, I'll ask them some questions, and we'll include some questions that come through the Zoom Q&A function or that have been emailed to us in advance. That said, let me introduce the panelists in the order that they'll be speaking. Bilal Sayyed, he's a senior competition counsel at TechFreedom. Previously was director of the Office of Policy Planning at the FTC for about 3 years, starting in 2018. Before that, he was an attorney in private practice, representing clients before the FTC and Department of Justice. And he's taught antitrust law as an adjunct professor at the Antonin Scalia Law School at George Mason University. Next, we'll hear from Alden Abbott. He's a senior research fellow in the Mercatus Center at George Mason University. He oversees the center's research on antitrust and competition policy. Prior to Mercatus, he was general counsel of FTC. He is a leader of the EBA's antitrust section. He's a regular antitrust columnist for Forbes Online, and he's co-author of the book Trade, Competition, and Domestic Regulatory Policy. And then finally, we'll hear from Asheesh Agarwal. He's an advisor to the American Edge Project and other organizations. His advice focuses on competition law and policy. He has served in senior roles at several federal agencies, including stints as Deputy AG in the DOJ's Civil Rights Division and Assistant Director of the Office of Policy Planning at the FTC. And he attended Northwestern University and the University of Chicago Law School. And with that, let me ask Bilal to start it off. Bilal? Bilal may be having some technical problems here, in which case, let us think Bilal logged off and may log back on. So why don't we start with Alden, who's going to explain the decision.
Well, thanks, Kurt. You've already told us something about the decision, but this dates back to an Justice Department complaint in October 2020, claiming that Google had maintained an illegal monopoly in violation of the Sherman Antitrust Act, Section 2. And based specifically, the Justice Department said Google had, quote, used its monopoly profits to buy preferential treatment for its search engine.
I'm hearing your voice in the background.
Yeah, but we get a so like it's like it's working.
I'll stop now for a second.
Let me.
Kind of nice to have someone.
It looks like Bilal is back. Bilal, are you able?
People like
Ashley, we
And
can hear you there.
at least my boys would hear from that course actually gets.
Let me text Ashley.
But I've been frustrated with plans other than running the group.
Alden,
Okay.
Bilal, so please resume.
Okay, great. So basically, Justice said
Does it pay leave?
that Google had used its monopoly profits search advertising to provide favorable treatment for its general search engines on devices, web browsers, and other search access points, creating what Justice called a continuous and self-reinforcing cycle of monopolization. Basically, the suit focused on Google's so-called exclusivity agreements involving payments and multi-billion-dollar payments, to be sure, by Google to web browsers and to device manufacturers such as Apple. Those agreements forbade pre-installation of any competing search service, but they did not in any way prevent consumers from accessing other internet search engines. Now, the presiding judge on August 5, in this case, Amit Mehta, issued an almost 280-page opinion holding that Google's actions had monopolized markets for, quote, internet searches and for, quote, general search text advertising. And so what's the antitrust issue here? Basically, the court said that Google's revenue-sharing payments, which it had received, and its advertising revenues, were huge, but it made these payments to other general search engines to prevent other general search engines, such as Bing, which is, of course, Microsoft, from gaining sufficient scale to compete effectively. According to the court, by maintaining a dominant share in the internet general search, Google obtained more and more data. This enabled Google to continue innovating and improving its search quality and ad targeting. And accordingly, consumers would continue to patronize Google's general search engine instead of its competitors' inferior products. Now, the problem is here, being a monopolist is perfectly illegal. What's perfectly legal? What's illegal under the antitrust laws is maintaining your monopoly through that's business behavior not on the merits that will tend to harm consumer welfare. Here, the argument was that Google had actually prevented other search engines from getting so-called minimum efficient scale, whatever that was, we're not sure, but maybe 10, 20, 30%. But it ignored the fact that by maintaining a large scale, by improving its search engine, Google was bringing more and more benefits to consumers. And antitrust monopolization law taught that if your actions are improving consumer welfare and bringing about innovation, they should not be illegal. The second point is that there's no duty. Yes, you should not inefficiently exclude a competitor in something that makes no economic sense, except you just want to keep it out. But here, Google made a good argument that we're just continuously improving and we have no duty to help our competitors. And the Supreme Court has made it clear in such cases as Verizon v. Trinco and subsequent cases that you don't have a duty to deal with your rival. Of course, you don't really have a duty to keep your rival in the market. That would be protecting a competitor instead of competition. We're concerned about, is the behavior bad for consumers? And so that's a pretty strong argument, I would say, that you have a now. So there'll be appeals undoubtedly dealing with issues such as should you have had a broader market definition? And by the way, Google said traditional sort of attempts to use the merger guidelines, the U.S. merger guidelines to define markets were ignored. Instead, old antitrust precedents from over 60 years ago justify the market definitions Justice used. So in short, that's where we are. We still haven't heard, and we'll hear more later about remedy, but remedy is important because even if somehow Google were found liable, and again, I pointed out the potential arguments against that, if there's no remedy that'll make things better, it's a case that really should not have been brought. And I will end my brief discussion for now.
Thanks, Alden. And I see Bilal is back. So Bilal, you were going to talk a little bit about the background of how this case came to be brought.
Sure, and apologies for the technical difficulties. Yeah, I thought as we talked about the discussion, I thought it would be useful and maybe just useful to remind everyone that there's been a history of one or both antitrust agencies investigating Google, either its I'll call it so-called conduct or acquisitions, and of course the major investigation was undertaken by the FTC in the around the starting in the first half of the first Obama administration and sort of concluding in late 2012, early 2013, where the agency did investigate Google for certain conduct in the general search market. Different theory of harm than we have in this case, also different facts than we have in this case. But at the time, 2012, 2013, concluded that the alleged conduct by Google was not anti-competitive and was in part efficiency enhancing, at least according to the commission, the full commission. There were other investigations of Google's conduct, both by the FTC and other jurisdictions around the world. But the U.S. authorities didn't move forward until this case, which came out in the Trump administration, which I think, as people know, was the subject of so-called clearance fight between the FTC and the DOJ. So that's a little bit of background, just suggesting that this case doesn't come out of nowhere, that the agencies, both in the U.S. and, of course, in Europe and elsewhere, have been investigating Google for some time, and at least in the U.S., the previous investigations had not found conduct worth alleging was anti-competitive.
Thank you, Bilal. And Asheesh, you were going to talk about possible remedies, and the reason I say possible is that phase of the case hasn't come yet. So I think the judge said that briefing on it should be done by the end of this year. So it'll probably be 2025 before we know what the judge's proposed remedies are. But Asheesh, go ahead.
Well, thank you, Kerr, and thank you very much to the Committee for Justice for holding this. And you're absolutely right. We don't know yet exactly what it is that the Department of Justice is going to ask for coming off the victories. The remedies phase of the case is it's actually very interesting. It raises some maybe broader philosophical questions about antitrust law, and you might say even about the purpose of law generally. And I think from a traditional antitrust standpoint, people would say that the purpose of antitrust law is to remediate past conduct and to deter and punish any violations of the law. That's why antitrust law provides for treble damages, for example. There is a newer view, most prominently expressed probably by former White House advisor Tim Wu. Also, Jonathan Cantor has expressed this view that antitrust law remedies really need to be forward-looking, and it's the job of the court not only to remedy the past conduct, but also to ensure as best as the court can that competition in a given market is going to flow freely on a forward-looking basis. So with that in mind, I thought I'd just run through briefly what the range of options might be, at least some of the range of possible remedies that have been bandied about publicly. So most narrowly, the court could ban Google from entering into exclusive distribution contracts, or distribution contracts no longer than 1 year. That is a core what the court found to be anti-competitive. this idea that Google was entering into long-term, exclusive, contracts with, with the equipment manufacturers, for example. A little more broadly than that, the court could, forbid Google, probably not forever, but for some period of time, from paying, at all to be the default, search option. That would be interesting. I'm not advocating for any particular outcome, of course, but it would be interesting. During the trial, Apple and others said that there's no amount of money that Google's competitors could give to Apple that would make them switch search providers. So it would be interesting if that was actually put to the test, and Google was forbidden from making those sorts of payments while Google's competitors were not. A little more aggressively, the court possibly could do some sort of choice screen. The basic critique is that Google, by paying to be the default option, gained this advantage in the marketplace, and if consumers were given a choice of which search engine to use, that would eliminate the that would eliminate whatever preference Google had. It's a possibility, I suppose. It's one that I suspect is not likely to make anybody happy. I think more antitrust traditionalists would say, well, gosh, it's really not that hard right now to switch search engines for consumers. I think the neo-Brandeisians, the more aggressive folks, might say, well, gosh, Google would still be allowed to keep all the advantages that it's received from its anti-competitive conduct, of all this access to data. And oh, by the way, the Europeans have tried some version of this choice screen. It hasn't really changed market dynamics very much. Beyond that, things start to get a little more aggressive in terms of options of what the court might do. So one option would be what you might call forced interoperability. So there is a possibility that it's been bantied about that the court could order Google to share with its competitors some of the data that Google uses to design its algorithms. There's both a fact issue and a legal issue there. The fact issue would be, well, exactly what would the parameters of that sharing be? So I think Google would probably say that it's not just the data that Google collects off its searches; it's the analytics that Google does that really makes its search engine so popular. And Google would say, gosh, we spend a lot of time and a lot of money to get these analytical tools to where they are, and you're going to force us to, why should you, the court, force us to share with our competitors this very expensive data? So that's the factual question. The legal question is, the court, in its opinion, really, adhere to Trinco, adhere to this view that companies do not have, a duty to help their competitors. So in that sense, it would be a little surprising if a court were to go that far, but I guess we'll see. Then, probably the final set of options would be, or the final ones that have been discussed, publicly, would be some sort of divestiture. So Google, in theory, could be forced to, spin off, the Chrome browser or the Android operating system. We'll very curious to hear what Bilal and Alden have to say about it. That seems, either of those remedies seems very, very aggressive for an underlying violation that, after all, was only that Google entered into overly long exclusive contracts. I think antitrust traditionalists would push back very hard on that. The court in Microsoft 20 years ago, the DC Circuit, did not order that very extensive relief. And there's also a factual question there: would some sort of divestiture even restore competition in the way that the neo-Brandeisians want? Because if, Chrome were a standalone company, for example, there's really not any particular reason to think that Chrome would set one of Google's competitors as the default browser. So you could, in theory, break up Google, have all these kind of negative effects in terms of stopping, breaking apart a vertically integrated company, while also maybe not moving competition forward. Anyway, a lot to talk about, a wide range of options.
What are the pros and cons in your view of these various potential remedies? And maybe you can also give us some idea of how likely you think each of them is.
Well, let me ask Alden or Bilal to talk on that. I'll wait at the end.
Sure.
I think the likelihood, I guess I'll jump in, divestiture remedies, I'd say very, very low. because I think, the court made some comparisons in this Google case with a 2001 Microsoft case, in which the Court of Appeals there seemed to be a much starker case that Microsoft had engaged in exclusive that had no economic benefit for anyone, had tried to manipulate it's a Java code to harm competitors. So there was a story that this is a monopoly, clearly well-established monopoly and operating system. Not a realistic argument about defining a market, and yet action that the Court of Appeals, several actions said were just in effect on their face anti-competitive. You don't have actions that are anti-competitive on their face. Exclusive agreements might be, but they can also have major efficiencies in ensuring distribution. And more than that, there's another efficiency argument I'll get into in a minute. But so the Court of Appeals totally rejected, as I said in Microsoft, the divestiture. The idea that divestiture would go forward in this case, I think, is very, very low. I mean, Judge Mehta himself praised Google for its innovation and how it had built this great browser, saying requiring that the divestiture of Chrome or whatever. And Asheesh has already pointed to that might not solve anything. Would seem to cut against the bulk of his findings in that were made in August. So I just think that's very low in terms of some sort of behavior to limit contracts. That's more likely. There was this it used to be thought that exclusive contracts of less than a year, although there are exceptions to that, are generally not likely to be anti-competitive. So the judge might talk about limiting terms of contracts. I think what the judge may be missing here is that these payments actually allowed Apple and other companies to potentially lower their costs to consumers to invest in improving their products. So it's not just, you're going to be distributing my physical product X, but now I can't make this agreement exclusive for too long a period of time. No, this is, you really are not going to be able to improve your product because I'm going to be making, probably, you have shorter contracts, smaller payments that could end up in less consumer benefit. And so I think there are some real economic questions that really were not dealt with by the court that might cut against such a remedy.
So Kurt, if you've got a minute, I'll
Sure.
just add on to that. I think a core reason, sort of hard to think that a draconian remedy like divestiture would be imposed here, really is there are some not only positive things that the judge says about Google in the opinion, but I think there's a real case to be made that the judge got the decision wrong. And I think, that's going to lead to, if not the district court, an appellate court, pushing back on any kind of very broad remedy like a divestiture. I think as you think about this case, or as people thought about this case early on in the process, maybe before it was filed, I think one of the questions that was sort of floating around was, what was the appropriate relief, right? You can in a sense catch the dog or catch the car here, but then what do you do with it? It's remedies that have been tried in Europe have not had the effect that the Europeans wanted them to have, and that suggests that and of course what that means is people have not moved away from Google. So I think here the courts are going to be very careful, if not the district court, the appellate court, in what relief they impose. I'll stop there, but I think it's difficult to see a very broad package of relief when what the court basically found was, these exclusive agreements were the problem.
Now I'll ask this to all of you. Is the court going to be responsive to the argument I've heard that if, the remedy is too draconian, that it could really hurt the U.S. competitively? For example, in our contest with China for, investment and innovation. Is the court going to care about that?
Well, Kurt, I don't think that the court would take into account that specific issue of Chinese competition from Alibaba and other tech conglomerates, and nor should it. Look, every U.S. company, big or small, should be subject to the antitrust laws, and if they are found to have violated them, the court should craft, I would say, in general, for anybody, a narrow remedy that addresses that harm. Having said that, I do think it's appropriate for the court to look at the impact on consumers of what what you might call a draconian order might do to Google and Google's ability to innovate, to invest. Google, like so many other companies, are investing heavily into AI, for example. The court's opinion was replete with discussions of how Google really has been investing very heavily to innovate, to improve its search product. And if you were to say dismember Google or order some of this forced intermediation, that maybe it would really hurt Google's ability to innovate consumers. I will also add to that, I do think it's appropriate for policymakers, in the administration and particularly in Congress, to ask that question about whether current U.S. competition policy enforcement is serving U.S. interests. Again, it is important that antitrust law apply to everybody. We don't have quote unquote national champions in this country where we deem that some companies are just so important to the U.S. that we're just going to give them a pass when it comes to the law. No, nobody's advocating for that. But I do think the policymakers should ask themselves the question: why is it that our antitrust agencies seem to really just be going after some of our largest and most innovative companies based on very, very aggressive, and I think some people say very attenuated theories of harm that involve a lot of speculation and no actual evidence that consumers are being harmed.
Alden or Bilal, do you want to add to that? If not, I'll throw another question out there.
Well, go ahead, Alden. Go ahead, Alden.
No. I just think that the point made that particularly it seems silly when you look at the fact that, as was alluded to already by Bilal, that in Europe, that remedies that were supposed to allow broader scope for other general search engines to be used, people kept going back to Google, and there isn't an answer about the harm that could be in terms of potentially less higher priced Apple iPhones, higher priced other products, if these payments, which were really just a payment to satisfy marginal consumers, yet other consumers who may be indifferent to look at Google, if they were doing that and bringing about benefits to these companies, which were passed on to consumers, really, where isn't that harm?
So, Kurt, I would just answer by pointing something out to the listeners. When the FTC sued Qualcomm right at the tail end of the Obama administration and the Trump administration, FTC sort of over because of a split commission continued that case. There was pressure, and this is public. There was pressure from the Department of Justice and other agencies within the government for the FTC to abandon that case because of potential national security issues. And like Asheesh had suggested, I don't think it's good that we allow non-competition issues, into competition cases. I think those of us on the panel here sort of make that point with respect to some of the concerns of the I don't say this as adversarial, the ad hoc the progressive wing that want to bring other issues in that are, relate to income or wealth distribution and other equity type issues. We ought not to allow it on the, sort of on the conservative side. I mean, it's just, there are a number of companies who are important for national security, and we don't want to give them, protection from the antitrust laws.
That's a good point. Folks who are more, let's say, free market oriented on antitrust, are constantly pushing back against progressives who want to bring all kinds of considerations into, beyond just what's good for consumers into antitrust law. So I guess we shouldn't do the same on the remedy side. What if, this was mostly a loss for Google, but are there any silver linings in the decision? Anything that Google can, be happy about? I'll throw that out to all of you.
So I'll start if nobody objects.
Sure.
Look, I think the court did sort of a clear decision. I think it made some mistakes, but there are some real nuggets of positive comments in there for Google. That's going to help them at the appellate court. So, I suspect Google would have preferred to win at the district court, but that certainly would have been appealed by DOJ, I think. And what you've got here is, a very, I look at this case and I ask myself, is this the effort to return us or take us back to the idea of no fault monopolization? Because Google entered these markets with what I think anyone would believe is monopoly power, prior to these contracts, and it's a little hard to see what additional monopoly power gained from these contracts. This is no different, and other people have made this point, so I don't want to take unique credit for it. This is no different, I think, than Coke paying to get a premium spot of shelf space because everybody competes for distribution, and Apple and as an example, Apple's iPhone is a premium shelf space, and somebody's going to pay for it. Somebody's going to pay for it. So, anyway, to come back to your question, what's good about it? There is a lot good in this decision for Google. They are, it looks, they look like an innovative company. The court rejected DOJ's contentions that innovation in this market had not occurred over the last, 5-10 years, the length of the contract. That's a huge positive. And I think the judge's mistake on the causation standard is a real positive. I'll stop in a minute. One thing I haven't seen is, the publicity around this case and the result, I think forgets or it mirrors the publicity around the antitrust district court decision in the Microsoft case more than 20 years ago, which basically suggested breaking up Microsoft was an appropriate remedy. Well, that didn't happen. And I think, people ought to read this opinion with that result in mind.
Now, you made reference to this decision pointing towards a no-fault standard. Do you think this decision, it's just a district court decision, tells us anything about the direction of antitrust law, how it's going to evolve in the courts?
I'll let others take that.
Okay, sure.
Or I can come in after, but I have some thoughts on this.
I don't really think so. People have to remember the distinction that between the district court, the trial court, and the court of appeals in antitrust. The trial court is building up a factual record, which will be given great deference by the court of appeals. It's looking at hard facts and trying to apply law as it pertains to those facts. The court of appeal, district court judges differ in their knowledge or background in antitrust, and they may differ in the weight they give or how they evaluate expert arguments. The key law, binding law, is made in the courts of appeals and ultimately the Supreme Court. And the courts of appeals in areas like monopolization and areas about exclusive contracts, on the whole, have emphasized the importance of using a rule of reason, looking for weighing potential efficiency justifications. So, and I guess what I'm just saying is that some district court decisions are well reasoned, others are not. Some are a mixture, but they really depend on very much on the judge. The courts of appeals decisions really, I think, still are pretty much open to applying Supreme Court standards on monopolization that make it really hard to win a monopolization case if it goes on appeal. So that's a distinction I'd like to emphasize.
All right, thank you. Did anyone else want to weigh in there? All right. Now the current legal standard, again, things may evolve, but the current legal standard is the consumer welfare standard, which basically says that when judging whether there's an antitrust violation, we look to whether consumers were harmed in some way, less choices, higher prices, whatever. Was this decision true to that standard? Was the decision good for consumers, maybe bad for consumers, maybe indifferent to consumers? And any of you can answer that.
Well, ultimately, the court certainly tried to phrase this decision in the language of consumer welfare, and ultimately the court found that Google's exclusive contracts did end up raising the prices for advertising, which was a demonstrable harm to consumers. Now, I will say that in reading all 277 pages of it, a lot of the court's discussion, quite frankly, did seem to be a little bit more about harm to competitors and how Google's contracts made it tougher for other competitors to break into the marketplace, without so much of a discussion about the ultimate harm in terms of degradation to the search engine or lack of innovation, et cetera. So we'll see what the Court of Appeal says. I do think that dichotomy, as Bilal was getting at, does provide grounds for appeal. I think another grounds for appeal is, and this might go all the way up to the Supreme Court, is whether the antitrust agencies need to use what's called the hypothetical monopolist test these days, or which is a much more rigorous, empirically driven standard that really gets at econometrically whether consumers are harmed or whether it's okay to use these. It's called the brown shoe factors in this Supreme Court case about 60 years ago. This is much more kind of amorphous in terms of what a market is, and which very much gets to consumer harm. I will make one related point, which is go consumer welfare standard. Assistant Attorney General Cantor, when he talks about that standard, will say, well, gosh, nobody can give me an exact definition of what the consumer welfare standard means, and he's right that there are some nuances in terms of how you would define it and apply it in particular cases. But where I think the Justice Department falls down is they don't have anything better to replace it with. The AAG Cantor and other progressives will talk about market realities, and we really need to, as people concerned about competition policy, look at market reality. Look at what is the reality of the marketplace. Well, that term, quite frankly, is empty of content. We don't know what that means at all. Whereas the consumer welfare standard, and again, the judge did at least play homage to that standard here, does give you a touchstone by which you can evaluate the actions of companies in the marketplace.
Yeah, I mean, it may not be 100% objective, but the consumer welfare standard is definitely the most concrete and objective thing we've had, after more than 100 years of antitrust cases. Speaking of consumers, they seem to be gravitating in the last couple of years towards AI-based products. ChatGPT is the most famous, but there are a number of things out there, and they are similar to search engines. And, Google has not so far been a leader in this area. So is this sort of like the Microsoft case in that, everyone's was worried about Microsoft being a monopoly, and then even though the court didn't do a lot, technology overtook things, and Microsoft did not become a monopoly? And might the same be true here, because people are gravitating towards AI-based search-like applications?
I think that's a good point, Kurt. Frankly, the ability, the fear, you've always had these fears that a monopolist will arise and somehow dominate the internet. Never happened. At one point, it was said MySpace will become the dominant social network, and then we'll expand beyond there. Never worked out. Microsoft never was successful in its entries into social networking. Facebook did very well in social networking, but it's lost a lot of its following to TikTok in some respects, and YouTube in a number of different ways. But it was never able. Well, some had thought, they'll now going to be able to leverage its social networking, and they'll expand into general search, and Google really has been very successful in general search, but as you say, they've perhaps been slower than some others to develop AI. So this idea that the first mover gets a lot of supposed monopoly power ignores the fact that this is a very innovative area. AI brings about new innovations. This is what the economist Schumpeter, almost 100 years ago, talked about: creative destruction. That if government doesn't intervene to create special legal privilege for a firm that has a large market share, indeed that happened to AT&T for decades. Government regulation protected AT&T from the markets. Let the market forces work, and indeed this is a perfect reflection. All of the things I mentioned over the last few decades. 1995, a Democratic administration, Clinton administration, decided we're not going to regulate the internet. It's new, it's commercializing, let it develop. And it was that decision that precisely allowed these specialized areas from search to social networking to some other areas. Now, AI is an input. It can be used. It can also be an output. But already the government is talking about concerns about AI collaborations being anti-competitive, and but again, without seeming to keep its eye on consumer welfare. Anything new is thought to be a threat, and I think that AI should be allowed to develop, and no assumption should be made. That's not that you're going to have a powerful monopolist. That doesn't say you don't. If you have mergers among major cloud computing or AI companies that you don't want to look at that. Of course you do, and there's standard antitrust tools to do that. But I don't think there's any reason to be particularly frightened or concerned about AI. We've heard this message before.
Kurt, I'm waiting to get a bunch of, sorry, well, just briefly, I'm waiting to get a bunch of angry texts from Googlers saying, what do you mean Google isn't a leader in AI? But it is true. They simply seem to be playing catch up to Microsoft when it comes to generative AI. But I just wanted to comment, I do think that this is an issue on which the district court's opinion might be vulnerable on appeal, and it'll be interesting to see how it plays out in the Remedies case, because the court specifically addresses the question in its opinion about whether generative AI is going to be a game changer when it comes to search. And what the court says is, well, gosh, we don't really have enough evidence yet that that's going to happen. Google's monopoly has been durable, and that statement probably is true from the date that the factual record in this closed in this case. I don't know when that is. But my goodness, I mean, 3 months today, 3 months from now, 6 months from now, 2 years from now, when this is all, wrapped up in the appellate courts, it sure seems like there is a trend in that direction. you have not only Chat GPT, Search GPT out there, you have Perplexity, supported by Jeff Bezos and other search engines out there that do seem like they are going to give Google a run for its money. So the fact, I said in a piece, innovation moves faster than litigation. So it could be a very different search marketplace in a year or two.
Kurt, I think the point you make is very valid with respect to the court's thinking about the remedy, right? But on liability, which is sort of backward looking, the fact that there may be future entrants into the market or who displace the market probably doesn't matter and probably shouldn't have mattered. But on the remedy, remedy is not really intended to be punitive. And if the idea is we're going to hobble Google, even though there are these other competitive alternatives in the future that we think may develop, well, I don't think an appellate court's going to go for that. And I think there was a little bit of that in the appellate court's review of the district court's decision of Microsoft. But I also think your comment about AI touches on the question about the consumer welfare standard and helps maybe square the circle with respect to Asheesh's comments on is how much in the decision is protecting competitors versus protecting consumers. And I think I think DOJ and maybe even the FTC, but I think DOJ has sort of confused this issue when it could have been a very simple, right? I mean, usually the fight with respect to, I think most people recognize that protecting competitors is not the point of antitrust law, but even those who are, sort of negative on consumer welfare standard. But I think most of us recognize that, the real question here is not whether we're protecting competitors, but the long term versus the short term, right? So if you're foreclosing competitors from a market, that may or may not be welfare enhancing, in the short term. The question really turns on whether is that welfare enhancing in the long term, right? Are you stifling innovation? Are you stifling entry? And that is a consumer welfare standard. So to me, it's sort of this trade-off of short-term versus long-term consumer welfare, and which do you have, confidence in measuring? At least that's, so I think this is a pure consumer welfare standard kind of case, but it starts to focus a little bit on the long term versus the short term. I think that's the way I square it.
And by the way, you may be giving people too much credit when it comes to what they think antitrust law is about. A lot of my very intelligent friends who may not know a lot about antitrust law, seem to think that it's a violation if you, do something that hurts your competitors, or if you are just too big. So, some education's probably needed for people to even understand that the consumer welfare standard has been the law for some 4 decades now. Alden alluded to some sort of tech phobia, for lack of a better word here. Do any of you think this decision would have come out differently if the defendant was, I don't know, airlines or grocery stores, instead of big tech, which is, of course, everyone's favorite whipping boy these days?
I'll take that just as a stab in the dark while Asheesh and Alden think about what the right answer might be. I think Google likely benefited from the fact that this is so-called new industry, fast-moving industry. If this were grocery stores or airplanes, I think the courts would probably have thought less about the potential harm from a wrong decision. I think, I disagree with the decision, but I think it's a serious decision, well written. I think the court tried to take take account of the fact that a wrong decision here, might stifle innovation. And that, I think, is what they sort of focused the case on, which is, did this stifle entry and innovation? So, if you get it wrong with respect to grocery stores, I mean, I don't want to diminish the importance of grocery stores, but who cares, right? And, Same with airlines. I mean, there are lots of fixes in the airline markets. There are lots of things that can improve airline markets, and a bad antitrust decision is probably pretty low on the totem pole there. But in these markets, bad antitrust decisions probably have some effect on future innovation. So I think the court took that seriously.
Well, I guess Bilal's not interested in eating or traveling, so there you go. I'll disagree with Bilal a little bit on this one. It is the case that the legality of an exclusive contract does depend a little bit on whether the companies entering into it have market power. So I don't think anybody denies that Google is a very big player, the biggest player overwhelmingly in the various search markets, however you want to define those. And if you had that equivalent in groceries or airlines, might a court find that such contract for foreclosed new entry, certainly within the realm of possibility. But like Bilal, it was a very well reasoned and thorough decision, but I am skeptical, like Bilal is, about the ultimate result.
Well, again, the more mundane antitrust cases involving groceries and airlines and the like will go on. What sort of implications does the US v. Google decision have for those, or is big tech sui generis in some way?
I mean, on the lower court level, look, I think they're all different. The court is going to look, what's the market, or is competition in the market? What facts tell you about recent competition or potential entry? So in a way, you're comparing not apples and oranges, but apples and pipe wrenches when you're comparing a district court opinion focused on these sort of search markets versus a district court opinion on involving supermarket mergers. They're very different animals, but the antitrust principles are the same, but they really are sensitive to the facts on the ground, which affect things, as I said, like entry and ability to exercise market power and things of that sort. I do think this. But I think also justice. We're not talking about that, but there's a lot of concern and criticism about the FTC's supermarket merger, the Kroger's Albertsons. That's a talk for a different time. But again, I think coming up with market definitions that seem very, very peculiar. As that's something we saw in the new merger guidelines. It still mention old market definition methodology since the 1990s, a more economic approach. But they also have this language about basically it's much looser. You're concerned about concentration. You're concerned about things other than economic efficiency and consumer welfare is really what's going on, I think, in at least some of these cases.
What can big tech, or for that matter, Kroger's, learn from this decision about how to avoid being the target of antitrust suits, or at least, winning if they are the target?
Yeah. I mean, I think it's regrettably this current leadership has this, implicitly there's a big is bad concern. So, for example, the mere capitalization of Kroger's and Albertsons relative to other supermarkets was a big deal. And the effort by the merging parties to come up with a divestiture package that would have retained competition in many markets, Justice shrugged off. As to Google, a big search engine, it seems that every big tech firm that's being sued in Europe, DOJ, of course, these suits, some of them started in 2020. But I mean, the fact is there seems to be an interest in emulating Europe, while the U.S. in the past tried to say, we believe in market forces can work. We don't have a paternalistic view that you want to have so-called precautionary antitrust. Just because something might go wrong, you prevent certain contractual actions or mergers or whatever in the present. Now we seem to be copying Europe, and there's been statements by the U.S. leadership praising the interventionist approach of the Europeans. So I think if you have a very large company that's in the headlines, and if it wants to merge or engage in inclusive contracts, that you can almost guarantee, I shouldn't say guarantee, but there's a high probability you're going to be sued because it's just part of the underlying philosophy. It's, find the victim and come up with, try and fit it into antitrust jargon as best you can. So I think you'd really need a change in leadership I would think, if you're concerned about the treatment of big companies.
Yeah, I mean, you're certainly right that at the FTC and DOJ right now, the antitrust leaders are do not really believe in the consumer welfare standard. Let's just put it that way. Do you think that would change under, probably, I'm going to guess, wouldn't change under a Harris administration? Do you think it would change under a Trump administration? And again, this is a question for all of you.
Well, the Trump administration did bring this case. Kurt, I want to go back to your other question because
Sure.
short answer is I don't think anyone is going to drop this case, whether it's Harris administration or another Trump administration. It's an important case, and actually, there's some opportunities here actually to develop the law that are, of interest to those of us who might be a little bit more conservative than the current administration. What do I think Google should take from this case, or Kroger's, Albertsons? I don't know what the grocery store folks should take from this case, but I think what we've seen in the last half decade or so is real questioning on the pro-competitive effects of vertical arrangements, vertical agreements, and that's what this is here. And I think maybe those of us who are very positive on the benefits associated with vertical agreements have gotten a little too accepting that the older research had sort of established that proposition and gotten a little bit I don't want to say lazy because it's other people doing the work, but I think there ought to be a real effort to think to further develop the literature on vertical agreements and the measurement of pro-competitive effects of those. And that's not unique to Google, but the firms who were sort of entering into these vertical agreements between two large firms with market power ought to be sponsoring some research, funding academics, funding centers to do good, credible work on updating the literature in response to some of the literature that's questioned the efficiencies of vertical contracts.
Well, what does this decision portend for a case that's already out there, the other US v. Google, the ad tech case? Obviously different court, different judge, different facts, but can we guess anything about how that'll turn out based on this decision?
Well, I wouldn't venture, a guess. Very different facts, but as I think we've discussed, there are a lot of positives in this case for Google in terms of the court repeatedly talking about how it is investing heavily, how it's innovating, how output is expanding. And back to your earlier question, I would say I think those are some of the lessons for other companies out there. Even if you're in a good position in the marketplace, keep doing all those things. Now, of course, Google did those things and lost this round one of this case, but I would expect, as we've talked about, that given everything else and all the other positivity in the court's opinion, that any remedy is much more likely than not to be fairly narrow and targeted to those specific practices the court found problematic. Briefly on the Trump administration, a possible Trump 2.0, I do agree with Bilal that I don't think this case is going away, but I think would see cases that are a little more grounded in empirical evidence and a little more recognition that the U.S. is in a dynamic, very competitive world economy. One of the things that bothers me about this case is that this DOJ has never laid out what does it actually want by way of a remedy. There's actually an executive order from the Clinton era saying, hey, government agencies, before you litigate, at least let the parties you're suing know what it is you want. That hasn't happened yet, and I would hope that a Trump 2.0 would be a little more transparent about that.
Correct me if I'm wrong. We're going back almost 25 years here, but wasn't there a perception at the time with US v. Microsoft that it was the Trump administration? I'm sorry, it was the Bush administration coming in that influenced Microsoft getting off pretty easily. Or am I remembering that correctly?
Yes, you are. Was a lot of criticism of the in a sense, the resolution of the case. But of course, the circuit, the DC Circuit's opinion really did narrow the case quite a bit. And, it would be silly of any administration to just sort of continue to bang their head against the wall when they get an appellate opinion in one direction or another. You can't just ignore it, and unless you really think you have grounds to appeal up to the Supreme Court. So but that honestly, that's that was I think that's a comment by people who weren't paying close attention to the Microsoft case. I mean, that district court opinion was quite broad and in some ways quite hostile to the company in a way, distinct from the conduct, and it was really an overreach by the district court.
In fact, the district court judge later on was after his initial decision was pulled from the case. He was concerned that there were some prejudicial statements he made that indicated a lack of judicial neutrality or impartiality in looking at the case. So that was particularly a case, and in this case, I mean, Judge made some may say he made mistakes, but I think there's a general agreement. He tried very, very hard. He spent a lot of work on looking at market definitions, looking at effects, he put a lot of work in a measured in a measured fashion. So that's another major difference.
Yeah, I mean, it was I can't remember whether we've alluded to this already, but it was well over 200 pages, the decision. So certainly nobody can fault the judge for not being thorough. We're just about out of time, so let me take. I wanted to have time for at least one or two audience questions. One question that was just emailed to me is what's likely on appeal to the DC Circuit, and perhaps if the Supreme Court wants to take the case, what's likely in the Supreme Court, and I'll ask that to each of you.
Well, I wouldn't venture a prediction. I think that there are, like we've talked about, there are a couple of issues that the courts and ultimately the case has enough impact potentially on the U.S. economy that maybe this does go all the way up. I think the market definition question is one. I think whatever the remedies question is, I do think whatever the district court determines, if it is one of the more aggressive remedy options that we've talked about, which I'd be surprised, I do think that an appellate court would look very, very carefully at that.
Any other thoughts on that?
I think what'll be interesting, assuming this goes to an appeal and it's not settled before that, I think the case puts squarely before the DC Circuit the so-called causation standard and the difference between the Microsoft case and the Remedies case, but both of which were decided by the DC Circuit appellate court. I think that is a very important question where the where the court comes out on what the DOJ have to show, basically. And I think that decision will impact, obviously, not only this case and the willingness of the parties to proceed, but it'll affect the EdTech case, right? What does DOJ have to prove in the EdTech case? So, my suspicion is that I will hazard a guess. I think the DC Circuit will find that the district court as good as thoughtful an opinion as this is, misapplied the in such the causation standard, and found the contracts were problematic without really finding harm. Whether the contracts, in a sense, it was the contracts that actually foreclosed Bing and others. So I think that's where they're going to come out, and in fact, if that's where it comes out, I don't think this case goes to the Supreme Court. I think it would potentially be settled after that.
Alden, any thoughts on what's going to happen on appeal?
No, I think that's right. There is some different lawyers, and this is getting into the weeds. I've read in certain statements in the Microsoft decision of 23 years, which was viewed as the last big time monopolization decision on bank, about sort of saying that, well, you don't really have to show even likely harm, just a tendency towards harm. And then there's a separate question about, you have to look at the but-for world. What would the world, who has to show what the world would look like if certain behavior hadn't occurred? And all of these really, and there have been arguments about how to best interpret the Microsoft case. And the DC Circuit might, after almost 25 years, want to look at that once again, say, really, let's try and clarify that, because both interventionists and non-interventionists have read certain statements not tied to particular facts in the Microsoft case in different ways.
Thank you, and I think we better wrap it up since we're over our time limit here. But I want to thank our esteemed panelists for making this a great panel, very informative panel. Thank you also to our audience, and look for our future webinars on antitrust, other tech-related issues, constitutional law issues, Supreme Court cases, and the like. Take care now.
Thank you.
All right. Thank you. Thank you.